Right.
Thank you.
Sorry, do you all see this?
Yes, very green.
Yeah.
Don't worry.
Yes.
You can change it.
No, green. Excellent.
I'm trying to find where is it? Oh, sorry. We're having some problems here. I'm searching for. Right, well, don't worry. I was just searching for the laser pointer, but I cannot find it, so you're gonna have to be patient.
Yes.
Where is it? 4-9. No, don't worry. It's okay. So let's move on.
Cecilia and Romy, please turn on the camera. Can you?
Right.
Thank you, Romy.
So sorry to be so. The thing is that I like pointing so that you can tell me.
But you are the host now.
Don't worry.
Okay.
Don't worry. I'm just.
There's the pointer. Yes.
No, that's the
Yes.
pencil.
Yes, that's the pencil.
Sorry, the thing is that I am a little bit of a freak as regards
Well, but
pointing
please,
because
go on,
I need.
Tomás.
I
Don't
need,
stop, please.
Very
go
good.
On. Okay.
Right. So you know that, well, this is our 6th lesson. It's always a good idea to state the date. It's the 25th of August. And we are starting a new unit. Do you remember which was the unit that we were just starting a couple of lessons ago?
Banking law.
Banking law, very good.
And contract law.
Sorry, how many students are there here present? We have Juan Ignacio, Cecilia, Romy, Maria. Is there anyone else?
And Juan Ignacio. There are four of them.
4. Right.
Cecilia, can you turn on your camera? Cecilia Melaki, if you are there.
Yes.
Thank you.
Right.
Can you turn on? Thank you. Excellent. Okay.
Right. Very good.
Okay.
Oh. All right. So we've got, at least, can you see the arrow here?
Yes.
Very good.
You know that I have seen the exam that Tomás has prepared, and there's a hint. Mind the collocations. Mind the collocations, because collocations are quite important for Professor Tomás for the exam.
Well, I am a language teacher, so language is
Collocations.
foremost.
Okay.
Right. So we've got more collocations. We are dealing with a new unit, so we've got new material. So you should pay a lot of attention, close attention to this. So, sorry, is it recording? Yes, yeah, it is. Right. Sorry. Cecilia, Romy, very good. Maria, can you read it?
Yes. A source of law.
Well, now you know it's a source of law. For the future reference, you'll know it. It's interesting source of. Do we have the same expression in Spanish?
Yes.
Which is it?
Fuente del derecho.
Fuente. I didn't know. Interesting. New topic. Right. Romina, are you there? Yes, she's there.
Yes.
I can see her. Read the next one, Romina.
To draft a bill.
To draft a bill. Very good. Which would be the expression in Spanish?
Confeccionar.
Oh, maybe I was thinking about maybe redactar, estipular. sorry, but no Romina, Maria, which will be the expression in Spanish?
Escribir.
Right, very good. Right, so,
Sí, también podría ser redactar.
interesting, very good. Cecilia, are you there? I think I can see you.
Yes, I am here.
Right, can you read the next one?
To drop up a bill.
Drop a bill,
Drop
very good.
a bill.
Right, Juan Ignacio, are you there?
Yes.
Very good, read the next one.
To debate a bill.
Bill. Interesting. Do we debate bills here?
Yes, we debate bills at the Congress
Congress. Interesting.
because you know that bills are los proyectos de ley, the bills.
Right. It's always a good idea to pay attention to the different verbs here because it can be very useful when writing papers and essays and theses. It's very good. So as to sound a little bit more, I'm gonna say, not
Accurate.
so tedious, a little bit more poetic because you know a lot of vocabulary because I told you. Right, Maria, the next one.
Yes. To issue a precedent.
Issue, which would be our expression in Spanish as regards a precedent.
No sé si hay.
Right.
Fallar.
Emitir un precedente. Emitir una sentencia que es precedente.
Maybe establecer.
Asentarnos.
Establecer un precedente, sí.
Asentarnos, precedente.
Sí.
Right. Sorry, do we work with precedents?
Yes, but it's soft law. It's not mandatory for the judges.
Interesting. I didn't know much about it. Very good. Romina, can you read the next one?
Yes, make a proposal or suggestion.
Or make a
Suggestion. Sorry, there's a typo there. It goes with double G. Suggestion with double G. If you write it down, you'll know it's suggestion with a double D. So double G. Very good. Cecilia, can you read the next one? You see, this is how it's supposed to be written, to be spelled.
To suggest an amendment.
An amendment.
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 Do we have amendments in our constitution?
Yes, there's a huge amendment in 1994.
94, but isn't that supposed to be a reform?
Yes, that's the amendment.
Right. Very good. All right, Juan Ignacio, the next one.
To make a decision.
Decision. So now you know that to make can be to make a decision or a proposal or a suggestion.
Make a suggestion.
So you know that that all these collocations may have different types. It may collocate with more than one expression. So you know in the future for any future examination, you know that it can have multiple meanings. It can have multiple collocations. So pay attention to it. Very good. Maria.
Yes. To form a new law.
Right. To form. To form. Do we use that verb to form?
No. In
Right.
Spanish, we don't say formar una nueva ley. En su caso decimos conformar una nueva ley.
Interesting.
O preparar,
Conform.
aplicar.
Very good. So, Romina, can you read the next one?
Yes, to hand down a judgment.
Judgment. Hand down. Which would be
Remember that phrasal verbs are informal. In case you want to be formal, you should say to issue a judgment. In hand down, because it's a phrasal verb, is informal.
Esto sería como dictar sentencia.
Sí, sí. Emitir una sentencia, un judgment, un juicio.
Right, but to dictate a judgment, I'm not sure if it's correct. Maybe
No, I
or
don't
to
say
emit
it's
a judgment.
It's not
It could
dictate,
be
it's to issue a
issue
judgment.
then. So that's the
It's
correct
a-
collocation. You know, to hand down or to issue. I
Yes.
cannot write it down there, so you'll have to write it down to issue a
Yes.
judgment as
To
well,
issue judgment.
not just to hand down. Very good. Who else is Cecilia? The final one there.
To decide a case. To decide a case.
To decide the case.
Which would be the expression in Spanish for that?
Decidir,
Decidir un caso.
yes. En un caso sería, ¿no?
En un
¿Qué te parece, Cecilia? En un caso.
Sorry, Cecilia, are you a lawyer?
Yes, Tomás.
Very good. Yeah, so sorry, the thing is that sometimes there are people that aren't lawyers, and so I don't know.
Yes. There's
Very
Ah,
good.
okay.
So you'll know it's to decide a case. Interesting. So now we go on with prepositions, and those are I love them. Don't you
No,
like
we hate them.
prepositions?
We don't love them. We hate them.
I love them.
Yes.
But the thing is that you have to be a special, very particular type of person to like it.
Okay.
It's so boring.
Ponele.
Right. Very good. Juan Ignacio, can you read it?
Yes. Source of law.
Juan Ignacio,
so
can
now-
you make an example using a source of law?
Very good.
Yes, sorry.
Can you read the example?
Yes. Legislation is the United Kingdom's most important source of law.
So now you know, pay attention to that. It's prepositional of law.
Over.
Be
Okay.
careful. Always be careful with prepositions because we don't tend to realize them, and they are far more important than we give them credit for.
Of law.
Very good. Maria?
Okay. To be drafted by a lawyer.
To be drafted by a lawyer. So now you know. Always pay attention to this verb, to draft, to be drafted, not to write down or to dictate or to emit, is to be drafted. And can you read the example?
Yes. This bill was drafted by a lawyer in the civil service.
Civil service, interesting. Romina, can you read the next one?
To put an idea forward for consideration.
To put forward, interesting.
Forward.
I love this verb, to put forward.
Put forward.
Yes,
Proponer sería. Put forward.
in this case, this is one of the few cases in which a prepositional, in which a phrasal verb is formal,
Put forward.
because you put forward an idea and well, you propose, and so actually it is a formal expression when you use it in thesis or essays. I'm sorry, I'm being annoyed by someone. Very good. So, to put an idea. Right, so who else is there? Romina or no, Cecilia, I think, or yes, Cecilia. Very good. Sorry, Romina, can you read the example?
Yes. This idea was put forward for consideration by the Department of Health.
Right, and always take into account this preposition, for consideration. But put forward can be used as a way to say proposes, maybe asserts, that sort of idea, rather than just saying he says, they say, he said, he puts it that way. But well, that's a different topic. Right, Cecilia, can you read the next one?
To suggest an amendment to something.
So now you know it's to something, to suggest an amendment to something, not for something. Can you read the example, Cecilia?
The House of Lords is suggesting to significant amendment to this bill.
So it is suggestion amendments to the bill. And well, so you said that we do have amendments in. Interesting. Sorry.
No, it's me.
Yeah,
saying
sorry.
I have to
Are
go.
you leaving?
Yes, I'm leaving, but I ask all of you to study for this the exam that we will post next Saturday for at least 5 days for all of you. Yes, so you
Right.
have to study
Okay.
the three units and go for the exam. It's a very simple exam, multiple choice exam with a Google form, but it's important for us in order to make an advancement.
To keep
in
tabs
the-
on your
yes,
progress.
yes. Thank you,
Yes.
thank you. Bye bye.
But
I'm leaving. So I
yes,
leave you
don't
with
worry.
this.
Don't
Thank
worry.
thank
You can
Bye-bye.
go.
Thank you.
You'll know that you're going to do okay on the examination because you are my students.
Oh,
Well,
humilde.
Adela, well, you want to be Adela's students or maybe Daniela's. I'm not sure.
Quedó grabado, así que ya.
Yes,
Sí.
I know. I know it's recorded. Don't worry because I edit that, so I know. Right. I can censor. I know how to censor stuff. Right. So Juan Ignacio. Oh, sorry. Oh. No, I think that's the one. That was the last one here. Very good. Juan Ignacio, can you read the final one?
Yes. To come into force.
To force. Can you read the example?
The new act of parliament will come into force at midnight tonight.
Which will be the expression in, sorry, Juan Ignacio, are you a lawyer?
Yes.
Very good. Which would be the expression in Spanish as regards when something comes into force?
Entrará en vigencia.
Right. Good. Interesting. I didn't actually think it's always a good idea to relate things in English to what we know so that we can afterwards we can remember them. So now you know it's into force. Always pay attention to the prepositions as well. Very good. So now we are going to do a little bit about work. Can you see? Do you see the screen? I'm not sure.
Yes.
Very good. So let's do a little bit of our work. We are going to read a lot today. I hope you like reading. Do you like reading activities?
Yes. I like it.
Thank you. Right, so for all of you, if you want, you can click on the link. I just posted on the chat box. If you want, you can do it. You can join here this session on what we are going to read now. I see
Okay.
one person, anonymous camel. Well, sometimes the font is too little. I couldn't make it bigger, but you can use this tool here, the zoom tool, or you can just read it from your screen because I'm sharing. You do see it right here do you see my laser pointer?
Yes, Tomás.
Yes.
Very good. So, Romina, can you read the assignment? This is a reading activity. We have to fill in the gaps here.
Yes. Exercise 1. Jack Winter and Shirley Hirst are first-year law students at the University of Chatsworth. Their studies will begin with contract law. The head of the law faculty has asked first-year students to read a book called An Introduction to English Contract Law before they come to their first lecture. The first section of the book that Chuck and Shirley have to read is about the sources of English law. This page is on the subject of statute. Fill the gaps in the text with the word or phrase from the box below.
So here you can see sources of law.
Sources of law.
So Maria, can you, all of you, I suggest you take a picture because afterwards the text goes on here on this frame. Goes on here.
Okay.
On this frame here, and so you should take a picture here. Can you do it? Maybe I can make it bigger so you can
Yes.
take a picture. There you go. Now you can take a picture. Right, very good. So we're going to read it here and we are going to fill in the gaps with these words. Maria, can you read all of them?
Yeah. Sorry. Amendments drafted into force, rejects, administrative, MP, formality, legislation, approves, unelected.
Elected. Very good. So now we're going to, I can read, and you can, and any one of you can tell me which would be the answer to fill in the gap there. Or I just told you, you can just click on the link and start filling in the gaps as you think it's correct. I don't see anyone here, but if you are, you know that we are here on frame number 2.
Yes,
So-
I'm here.
Sorry, I don't.
You can see
I
me.
don't actually see you online. So, well, but if you are there, if you are here with me,
Yes.
as the song says, then it's okay. Very good. So we are going to start reading here. Cecilia, can you read the title?
Okay. An Introduction to English Contract Law.
Go on reading.
Chapter 1, Search of English Law. In England,
Sources.
there is no civil code. English contract law is therefore not codified. Instead, we derive our law from 2 main sources, which are statute law made by Parliament and case law made by judge.
All right.
Continue.
No, let's leave it like that. Everyone, I say, and you repeat. Sources.
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 The final Z is optional if you want. Right. And well, there we have judges, but we're not going to focus on phonetics because I've been told not to. Right. Romina, can you read it here?
Yes. Statute. A statute is also called an act of parliament. In England, statutes have been the most common source of new contract law since the 17th century. A new statute passes through 3 stages. Stage 1, a proposal is made for a new law. A proposal can come from either a government department or an individual, blah, blah, blah.
Individual what? What do you think?
Individual.
So, for example, here, Maria, can you read the next sentence here?
Yes.
An individual.
Sorry, I didn't hear, Romina.
Leyendo lo que sigue, ahí debe ser el individual.
Claro, sí,
MP.
sí, seguro.
Claro, no sabía, justo
Seguro.
no sabía lo que era.
Sorry, so do you prefer if we read all of it first?
Como quieran. Yo justo esa me di cuenta.
Muy
le-
aparte.
Sí, como quieran.
Romina, go on reading.
Okay. Entonces, an individual MP. diría ahí. This stands for member of parliament. If the proposal comes from a government department, then it will usually be drafted by a lawyer,
Drafted.
the civil service.
Drafted, very good, yes.
Yes, and the first one is MP.
MP,
Yeah.
yes. Normally, if you read a paper, maybe an English paper, you will find that most of the time when they talk about any of all the scandals regarding the members of parliament, they often use that term, MPs.
Okay.
With all the scandal as regards the prime minister, probably they use that expression, MPs. Oh my God. Right, drafted MP, very good. Sorry, Juan Ignacio and Cecilia, do you understand what we're doing?
Yes, yes.
All right, all of this is on the platform, on the Google Classroom. You should know that. Did you revise a little bit of the material that I uploaded?
Okay.
Yes.
Yes.
Very good. It's just for me to know so that we can all get together and share our insights.
Okay.
Right. Very good. Drafted by a lawyer, which is what Romina said. Very, very good. So now you know. That's why I teach you prepositions. Now you know. By a lawyer in the civil service. Very good. Maria, can you go on reading?
Yes. The civil service is the organization which manages the government's affairs.
Government what? Well,
Maybe administrative.
maybe Cecilia and Juan Ignacio can tell us what they think.
Administrative, maybe.
Yes.
Yes, it is administrative.
Yes.
Lower. Administrative, very good. Go on reading, Maria.
Okay. Sorry. This proposal for a new act of parliament has to be drafted, sometimes called drawn up, so that it accurately states the government's intention, and it must be as unambiguous as possible in the language that it uses.
It uses. Go on.
Go on.
Go
Okay.
on.
Instructions as to what is to be included in the proposal are given to the civil service by the government department responsible for it. When the proposal is drafted and published, it is then referred to as a bill. A private member's bill is a bill put forward for consideration by an individual MP. Relatively few private members' bills become law as compared to those introduced by the government. A bill is debated in the House of Commons. If the House of Commons a bill, which it does by taking a vote, then it is passed on the next stage.
So, for example, here, Juan Ignacio or Cecilia, which type of word should we use here? If the House of Commons, a bill, which it does by taking votes, then it is passed to the next stage. Which type of word do you think? Don't think about these ones. Just tell me the type of word that could go here. A verb. So, for example, Maria, can you see, or Juan Ignacio, can you see a verb there?
Maybe it's approves.
Maybe. It could be approves. Very good.
Debe ser esa porque dice que de ser así pasa a la siguiente etapa.
Very good. Yes. Correct. Very good. I was actually thinking about reject, but you were right, which it does by taking a vote, then it is passed on to the next stage. Right. Very good. Sorry, Cecilia and Juan Ignacio, don't hesitate to say what you think, what do you believe. Everyone's here to, well, to share what they think, what they know. So, well, we just said it approves a bill, which it does by taking a vote, and it is passed on to the next stage. And now, remember to take a picture. Did you take a picture? Because we're going to go on working with the rest of the text.
Okay.
Right. Very good. Yes, I do have it here as well. So, the stage 2. Cecilia, can you read it?
Okay. Stage 2. The House of Lords now debate the bill. The members of the House of Lords can suggest to the bill. And if they do so, it will go back to the Commons of its considerations of the proposed change. Continue?
Yes. No, wait. So everyone, what do you think about letter E? Well, which could be the answer there?
Amendment.
Can suggest amendments to the bill. Does anyone have does anyone have an objection? Wow. Yes.
No, I think so.
It's okay.
Amendments, very good, yes. Amendments to the bill, so now you know. It's amendments to the bill here. I love that name, like Bill Murray, like the actor. I love that guy. Right, Cecilia, can you go on reading here?
The power of the House of Lords is limited, and a bill can become law even if the House of Lords it.
So, Cecilia, what do you think? Which type of expression could be useful here? Not one of the ones that we are writing down, just type of word. Even if the House of Lords, what?
I don't know, Tomás. I can have the hand this.
Right. So, well, maybe Juan Ignacio can tell me which type of word do we need here?
A verb?
A verb. So, can you tell me the other verb that was missing within the options that we are working with? We just established that
Maybe
when you use
if
the
you
word
go back-
approves here.
Yes.
So which would be the other verb that that could go there?
Rejects.
To reject. Very good. I'm going to write it down. Don't worry. So even if the House of Lords rejects it. Rejects it. Right. So Maria, can you go on reading?
Yes, this is because the role of the House of Lords is to advise and to make suggestions about the law rather than to formulate it. The process reflects the fact that the House of Commons is a democratically body, and the House of Lords is not.
Democratically what? So we have rejects. You can start crossing them down. Rejects, elected, approved.
Elected.
Elected body, democratically elected body. Which gives you the hint that it's elected.
The word being democratically.
Democratically, yes. Very good. Well, I try to aim for all of you to use the word adverbs or verbs or adjectives, but I do think that it's too much. Right, elected body and the House of Lords. So can you go on?
Yes, when a bill has passed through the House of Lords, it goes on to the final stage.
It goes on to the final stage. Right. Juan Ignacio, can you read stage 3?
Yes. The monarch, the king or the queen, gives the royal approval to the bill. This is called the royal assent. This is actually only a
What? What do you
as the
think?
monarch formality, I think it was.
Formality. Yes, it could be very good. Formality, yes.
As the monarch does not even see the full text of the bill. Once the royal assent is given to a bill, the new act of parliament will come on the date stated in the act itself, or at midnight on the night that the royal assent is received.
Right,
Oh.
so will come what? I just told you that. We're missing into force or legislation?
Into force.
Into force, very good, yes. So remember this is what gives you the hint. Come, it will come because remember the collocation, come into force. So now you know for visual reference. So will come into force on the date stated in the act itself. Can you read the final part, the final sentence, Juan Ignacio?
All of the statutes created by Parliament are known collectively as legislation.
Legislation. Is it true? I'm not sure.
Yes.
Legislation is the only one. So yes, we have legislation. Legislation. Perfect. Very, very good. You know a lot, everyone. Congratulations. Because
Thank
I
you.
taught you. You're my students, remember. So you know a lot. All right, so we're going on with exercise number 2. We still have time, so you're not you're not skipping this part.
Okay.
Right, maybe, no, Maria, can you read the assignment?
Yes.
Make it bigger. Right.
Exercise 2. The second page of the book that Jack and Shelley have to read contains information on the subject of case law. Fill the gaps in the text with a word from the box below.
Can you read all of the words there?
Yes. Binding, judgment, distinguish, precedent, judge, instance, guidance, and common.
Common, very, very good. So you should all take a picture. Can you do it? Because then again, we have to.
Okay.
Right, yes. Guidance, judgment. Yes, very good. Okay. Okay, so Romina, can you start reading? On the first part, you should all know that we are going on with frame number 4, which is past frame number 2. You should do it with this arrow on the upper part of the top screen bar. Okay, so Romina,
Okay.
can you read the first part here?
Yes. Case law. Case law comes from judges. It's also known by 2 other names. These are the blah 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 law and blah 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 made law.
So which could be the answer there? The law and made law.
The common law.
The case law, the common law. Very good. And well, everyone, which could be the next answer here? And what made law? Remember, which is the basis for the English legal system?
Judge made law.
Judge made law. Well, I was actually thinking about precedent made law, but then we're going
okay.
to let's see afterwards if you were right, Maria.
No, I can be wrong.
Well, let's see. We still have to go on reading, so we have time. Precedent. Sorry. Precedent. It sounds like president, but it's precedent. It's not president, it's precedent. Because it goes with an E and not a E, although it sounds rather similar. All of you, any one of you, Juan Ignacio, Ricardo. Hello, Ricardo, I didn't see you there. Ricardo, are you there? Sorry, who is Ricardo? Because I see.
Maybe he has not a microphone.
No, he has it, but I'm not sure if he is listening to me.
Okay.
I just want to know because I don't know. I don't have the list for everyone who signs up for these calls. So it's the president made law. So Juan Ignacio, can you go on reading here?
If a judge makes a decision on a point of law that has never been considered in court before, the judge's decision can become a statement of law. In the English legal system, this statement forms the law for the future. It is called a...
But in that case, I think Maria was right. Because it says here that it should be considered for the future. And for example, remember that we were working with presidents. So
Yes.
presidents.
President.
So congratulations, Maria. You were right. I think so.
Thank you.
I'm not sure. Although it could be judgment. Because
No,
judge,
judge. No, judge. No sería.
judge.
Porque
It's
Too
judgment
much
made law.
judgment made law.
But it sounds funny. Judgment made law. That's why I like it. I think Ricardo just left, but don't worry, he'll come back. They always come back.
Qué miedo.
Yes. Very good, really good. So, Romina, can you read here the next part?
yes. An important principle of the system of precedent is that the legal reasons for past decisions must be clear. For this reason, a blah 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 given or handed down at the end of the case includes the judge's reasoning in giving his or her decision.
Right, Romina, so which could be the Juan Ignacio or Cecilia, which could be the answer here? Remember all the collocations that I taught you. For this reason, a given or handed down. Remember which was the collocation for handing down?
Sí,
Like to rule.
judgment.
Yes, judgment.
Judgment, very good, yes. Remember to pay attention. That's why I teach you all the collocation.
Yeah.
Okay.
Right.
Mhm. Judgment.
It's nothing personal. Right, so let's scratch it right there. Instance binding. Hand it down. At the end of a case includes judge's decision. All right. Where did we leave it? Maria said, sorry. His or her decision. Cecilia, can you go on?
Yes. In other words, as well as giving a summary of the facts of the case, a judge will also explain the principle of law he or she used in coming to the decision. The reasons for deciding the case are known as the ratio decidendi. And this is what creates the precedent of future judge to follow.
Right.
The rest,
Everyone, repeat after me. Judges.
Judges. Judges.
But give
Judges.
emphasis on the final Z. Judges.
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 Precedent for future judges to follow.
To follow. Very, very good. I like it. Yes. So, for example, do we have here in our legal system, do we have a ratio decidendi?
Yes, ratio decidendi.
Very good. I have never seen that word. That's why. So, Juan Ignacio, can you go on?
Yes, the rest of what the judge says is known as the obiter dicta. Our judges in future cases do not have to follow it. It can be problematic for lawyers to separate the ratio decidendi from the obiter dicta because the judgment does not contain any
What?
as to which is which. Guidance.
Guidance. Do you all think the same?
Yes, I think so.
Yes.
Guidance. Yes, very, very good. Any guidance as to which is which? Very good. Okay, so did you manage to take a picture, all of you? Because we are
Yes.
now going on with the next part.
Yes.
Don't worry, there is very little to go. Afterwards, you can all go and have dinner or have a cup of coffee. Depends on what is the time you have dinner. Right, so let's go on with the next one here. Oh, it's so long. I didn't realize. Uh-huh. Romina, here, can you read it?
Yes. There are two important factors in deciding whether a judge's decision becomes blah, blah, blah upon future cases, meaning that there is an obligation to follow it.
Well, so a decision becomes what?
Binding?
Yes.
Binding. Very good. Right. Binding. There is an obligation to follow it. Go on reading.
The decision that forms the precedent must have come from a court senior to the court hearing the later case. Judges at the lower levels of decision making, often called courts of first
First what?
instance.
Instance. Yes.
Very good. We do have that expression, right? Court of first instance.
Yes.
Yes.
What is a court of first instance?
El juzgado de primera instancia.
Yes, well, I could ask you what does it do, but it's not relevant, so let's go on. First instance
Do not generally issue binding precedents.
precedents. Very good. Go on reading with the final one here.
Okay. The fact of the later case must be similar enough to the fact of the precedent case. A judge can decide that the material facts of the case before him or her are sufficiently different to allow him or her to distinguish
Yes. Distinguish.
later
To distinguish.
and the present.
Very, very good. Everyone, I say and you repeat sufficiently.
Sufficiently.
Sufficient.
It's hard to pronounce, that's why. Sufficiently,
Sufficiently.
that's why. Between this latter case and the precedent. Very good. Maria, can you go on reading with the following part
Yes.
here?
It is also possible for a court in a later case to decide that the precedent created by an earlier case should no longer be the controlling law and the new precedent is set. This is called overruling. However, the later court must be of a higher level than the original court. The House of Lords, which is the highest court in the UK system, can overrule its own earlier decisions. After the House of Lords, decisions can be overruled by the European courts.
Right, European courts, right. My God, it's so complex. Do we have so many courts in our system? Or is it a little bit simpler?
No, it's more or less the same.
So you have the House of Lords, you have the courts of first instance.
Courts of first instance, and then we say it the Cámara.
Right, but there are no chambers on the British system, so there is no equivalent.
Yes.
Very good. Cecilia, can you go on reading here, this part?
Okay. Case law and statute are where most English law and certainly most English contract law come from. To find out more or to read some cases, you can visit the Law Reports website at
Reports. www or
Three-
www.lawreports.co.uk. Nobody cares, so let's move on. Sorry, Juan Ignacio, can you read the final part here?
To find out more about statute or to read some more statutes from the UK, you can visit the website of the Office of Public Sector Information.
Office.gov.uk. Nobody cares. You are right. Very good. So, do you have the listening? Have you downloaded the listening file?
Yes.
No, ese que está ahí en la Prime.
Yes, yes. Let me just
Okay.
put it right there. Yes. Sorry, I'm going to play the audio, and you're going to tell me whether you can listen to it. Here, maybe Romina, can you read the assignment? It's on the final frame, number 6.
Yes. Exercise 1. Today, Jack and Chili are going to a contract law lecture. Listen to the lecture and answer these questions. ¿Leo las preguntas?
Yes.
Do contracts involving large amounts of money need to be in writing in order to be valid? B. In which American state was Pennzoil based? C. In the example case of Pennzoil buying Getty Oil, there was no written contract. How did they agree the deal? D. A few weeks after Getty Oil had agreed to sell to Pennzoil, another company announced that it had bought Getty Oil. What was the name of the other company?
Right.
How much money was Pennzoil awarded by the court in damages? F. What type of contract does the lecturer say that her students will most often encounter in their careers as lawyers? G. What used to be necessary in order to make a deed valid?
Right. So I think that's the final part here. Yes, it's the final one. So I'm going to play it and you're going to tell me whether you can listen to it because I'm not sure how good it is.
Unit 3B, the language of contract law. Unit listening.
Sorry, can you listen to it?
Yes.
Very good. So now I'm going to play it again. So keep focus on the screen. Which am I sharing? Which tab am I sharing? Is it this one or maybe the audio?
Yes.
But, well,
Yes.
don't worry.
No, it's
Unit
the
3B,
Jamboard.
the language of contract law.
Very good.
Unit listening.
The subject of today's lecture is contract law and the different forms that a contract can take. Not all contracts are alike. In the UK legal system and in the USA, a legally binding contract can be created in several different ways. For example, a contract can be either oral or written. Most legal systems around the world accept the idea that a spoken agreement can be as valid as a written agreement. There is a third way to create a contract, and that is in the form of a deed. Once we've established the form that a contract might take, we need to consider its scope. Contracts can be unilateral or bilateral in nature, creating quite different obligations for the parties concerned. All of these points require some explanation. Let's begin with oral contracts. An oral contract is a spoken agreement. In most cases, it's just as valid as a contract in writing. I am often asked if an oral contract would be binding if it were for a huge amount of consideration, let's say £1 million. The answer is
Tomás?
yes, it would be binding. It doesn't matter if a
Creo que no
contract
es
involves
ese.
a large amount of money or not. A spoken contract is equally as binding upon the parties as a written one.
It is, Maria.
It doesn't say anything about Pennzoil or Getty Oil.
But it just talked about a large amounts of money. Be careful, listen to it.
Okay.
One of the most famous cases in this area of law is from the United States. In December 1983, a Texas company called Pennzoil agreed to buy another company called Getty Oil. The deal was done with a handshake, but no contract was signed between the two companies. Pennzoil then announced the acquisition of Getty Oil. However, a few weeks later, a third oil company called Texaco announced that it had bought Getty Oil. Remember, no written contract had ever been signed to say that Pennzoil had already bought Getty Oil. It seems that the people at Getty Oil felt that a handshake wasn't enough to seal such an important deal. However, when Pennzoil successfully sued on the grounds that Texaco had interfered in a legally binding contract, they were awarded $10.6 billion in damages. This case shows that it would be a serious mistake to think that because there is no written agreement, then there is no contract. To move on now to written contracts. They have been in use since the time of the Romans, and with good reason. A written contract helps avoid disputes. When you have a written contract, both sides know the subject matter, terms and conditions of their transaction. A written contract is usually very detailed, but will generally include basic information such as the parties' names, the parties' obligations, anything that might happen that will excuse performance of the contract, and the result of a failure of one of the parties to perform. This is the most common type of contract and the one that you will come across most often in your professional lives. If we now look at deeds, a deed is a contract that must be in written form in order to be legally valid. It usually grants a right to do something or to have something. A deed used to need a seal, often made from red wax, to make it valid, but these days a signature is usually enough. Any contract for the sale of land must take the form of a deed. And finally, we must consider whether a contract is bilateral or unilateral. The more common of the two is a bilateral contract. This is an agreement in which each of the parties to the contract makes a promise to the other party. For example, in a contract for the sale of a car, the buyer promises to pay the seller in exchange for the seller's promise to give ownership of the car. In a unilateral contract, only one party to the contract makes a promise. A typical example is the reward contract. Anna promises to pay a reward to Kit if Kit finds Anna's dog. Kit is not obliged to find the dog, but Anna is obliged to pay the reward if Kit does find the dog. You will need to read about the formation of contracts in your textbooks in time for tomorrow's seminar. Please look at pages 335 to 387 and be prepared to answer questions on this subject tomorrow. Thank you.
Sorry, shall we listen to it again? And you're all muted.
Sorry. A mí me faltaron dos. Si quieren, igual las corregimos.
Only 2. Very good. Maybe the rest of you can
Yes.
join and tell us. So, for example, any one of you, do contracts involving large sums of money need to be in writing or in order to be valid?
I think she said no.
No. There
Yes,
you
she
go.
says no.
That's it. It's a yes/no question. Very good. So I was curious, in which state was Pennzoil based? I couldn't hear that. I couldn't make out that last part. In which American state was Pennzoil based?
Pennsylvania,
Texas, escuché yo.
Texas.
Texas. Okay, let's work with Texas. Texas, yes. Well, maybe Juan Ignacio and Cecilia, could you make up any of the answers?
I'm not sure, sorry.
Well, maybe G, F, or D, or A, or E. But if you're not certain, then there's no problem. So, for example, in the example case of Pennzoil buying Getty Oil, there was no written contract. How did they agree the deal? Were you able to listen to that for that answer?
With a handshake.
With a handshake, yes.
Yeah.
In Argentina, do oral agreements validate a contract, or does it all have to be in writing?
No, it's valid, but it is difficult to prove.
Right, in a case, right. Sorry, and do we have handshake contracts, handshake deals with a handshake? Very good. With a handshake, yes. So, were you able to, any one of you, were you able to listen to, sorry, Liliana, are you there? Who is Liliana? Although I'm not sure, because people come and they leave their mic open. Very good. So, any one of you, were you able to make up the answer for letter D? A few weeks after Getty Oil had agreed to sell to Pennzoil, another company announced that it had bought Getty Oil. What was the name of the other company?
Texaco?
Texaco?
Yes.
Could be Texaco.
No, I didn't hear that. Maybe it's Texaco. Sin S.
Right.
Without
Texaco.
S.
Right, Texaco. Right, so how much money was Pennzoil awarded by the court in damages? Cecilia and Juan Ignacio, or maybe Liliana as well. Were you able to listen to that part? How much money was Pennzoil awarded by the court?
She says $10.6 million, I think.
10.6. Do you all think that?
Yeah. Billion.
Maybe billion. Much more.
$10.6 billion. That's a lot.
Eso escuché, no sé.
How many pesos is that? 30 billion pesos.
Mucho.
$10.6 billion. Sorry, and what type of contract does the lecturer say that the students will most often encounter in their careers as lawyers? I couldn't make out that part. I
The
was
deed?
curious. In the form of a deed.
But I'm not sure too. I'm not sure too as well.
Me neither, but what do you think, Romina or Juan Ignacio or Cecilia or Liliana, if Liliana is listening?
Calculo que escrito, debe ser, pero written.
Deed? Well, let's go with deed. So, what used to be necessary in order to make a deed valid?
Written.
I found
Romina
that
said it.
answer to be interesting. I didn't know that. What used to be necessary?
No, yo dije written, que creo que
To be in, yes, as Romina says, to be in written form.
escrito, digamos.
You mean letter G or letter F?
F,
To be
written.
you mean written contracts?
Yeah.
Written contracts. So tell me, what used to be necessary in order to make a deed valid?
Eso no sé.
To be in written form.
No.
Why not?
She said a seal. Do you remember? Which color?
No, I don't know.
Well, a red seal. But nowadays, what is necessary for a deed to be valid? She said it. Or what is enough for a deed to be valid? But well, I can see that you no longer care. You know that she said a signature is enough. And so, well, I'm gonna stop recording here, and I'll see you boys and girls next week. And I hope you liked it.